I asked last week in the House when we would see a particular document, and unfortunately the answer I got was an answer to a different question. But I have been pursuing this matter for some time. It seems at this point that only the Green Party is interested in this issue and that I'm the only member of Parliament asking questions about it. I hope that by raising some concerns today, we'll see more parties take this issue up in the House. The issue that I want to address this morning are these two agreements. They were signed by Prime Minister Stephen Harper in Vladivostok at the APEC meetings on September 9th. This one was first announced in February when the Prime Minister was visiting China. It's titled An Agreement Between Canada and China for the Promotion and Reciprocal Protection of Investments. What this document does, it's been promoted by the Prime Minister, and in fact, if you open to the first explanatory memorandum about this treaty, the first thing you read is that the agreement provides Canadian investors operating in the People's Republic of China with additional legal protection. The summary that you'll find on the websites as well, the Foreign Affairs Canada, and in this explanatory memorandum, don't say much about the additional rights and protections given to Chinese investors operating in Canada. Everything we've seen in our press has been about how this will protect Canadians operating in China. What this agreement does, in fact, is far broader than what we've read in the newspaper. In fact, we've seen a sort of a go slow series of stories lately that a full free trade agreement with China will be a long time in the future, that we're not there yet. But this investment agreement contains a lot of the same provisions that you would see in NAFTA. And in fact, this agreement now signed by Stephen Harper, not yet ratified by the House of Commons, and the question which I want to put before the House is, will we in fact be asked to ratify? This could in fact be ratified by Privy Council and not come before the House of Commons. So the process around this is a grave concern. But I think the Prime Minister has already committed himself by signing this to a series of actions which mean that any objective review of the CNOOC offer to buy Nexen is compromised. In Article 3 of this agreement that the Prime Minister has already signed, it states, each contracting party shall encourage investors of the other contracting party to make investments in its territory and to admit such investments in accordance with its laws, regulations, and rules. So, en français, chacune des parties contractantes encourage les investisseurs de l'autre partie contractante à faire des investissements sur son territoire. Et au sujet de la question de CNOOC qui veut acheter Nexen, maintenant nous avons le Premier ministre qui a déjà signé un promis pour encourager les investisseurs chinois pour acheter les entreprises canadiennes. So I think that's of concern. Getting into the depth and the details of the agreement, this agreement means that China from now on will receive most favored nation treatment, that the concepts of fair and equitable treatment will be applied, and that treatment means, as anyone understanding trade rules mean, that we cannot now treat Chinese resources or labor any differently than we treat Canadian, which I think raises other questions. What would happen if, for instance, there was a concern among Canadians that, for instance, the Enbridge project, we know PetroChina has said it wants to bid to build the pipeline across northern British Columbia. And we've already seen commentary that says, well, PetroChina's bids are generally competitive because of their lower labor costs. I think Canadians wouldn't want to imagine that the jobs that are promised from various pipeline projects will be jobs for Chinese workers. They'd like to think they were jobs for Canadian workers. As I understand this agreement, we could not specify that projects would have to have Canadian workers because that would violate fair treatment and best and most favored nation practices. We are allowed, and again, this is the national treatment sections are expanded in Article 6. In Article 7, I know people are wondering what we can do about insisting that Canadians be on the boards of directors of Chinese corporations. In Article 7, it specifies that a contracting party may not require that an enterprise of that party that is covered investment appoint individuals of any particular nationality to senior management positions. So you can't specify that certain senior managers have to be Canadian for Chinese corporations operating in Canada. You can specify, however, that a majority of the board must be either Chinese or Canadian for reciprocal investments. Not to go through the entire agreement, the next most important sections relate to what are basically mirrored on Chapter 11 investor state provisions as found in NAFTA. And under Chapter 11 of NAFTA, if there is an expropriation, but expropriation in the common sense meaning you're, sort of Hugo Chavez style, nationalizing an enterprise. That's how most people understand expropriation. In the Chapter 11, which has now been conveyed into various bilateral investment treaties, it's not a full-on expropriation that's required to trigger the right of another country to sue Canada for damages, or of another, in the context of NAFTA, not another country, but a foreign corporation to sue us for damages. The expropriation need only be that the foreign investor has lost its expectation of profits. In other words, you pass a law in Canada and it reduces the expectation of profits of a foreign investor, and that is something considered tantamount to expropriation. So those provisions appear in Article 10, which is the expropriation sections, and gives the Chinese state-owned enterprises, which are essentially an arm of the Chinese government, the right to sue Canada if we pass laws that they think reduces their expectation of profits. I think this requires a very serious study by the Canadian public, by the Canadian Parliament. It does have a series of exceptions which are worth noting. There has been some effort to put in this language that there would be, these provisions would not apply if the laws that were passed were relating to the environment or other aspects of public policy consistent with Canadian law. I do want to stress, though, that there have already been a number of commentaries on this point, that these exceptions are very poorly worded and hard to enforce, so I don't take much comfort in them. But I note the exceptions, by the way, which are found in Article 33 for people who find the agreement later. One of them looks to me to operate in the same way that the energy chapter of NAFTA operates. In other words, there are contracting parties are allowed to take steps, and I'll quote it here just to give you a sense, relating to the conservation of living or non-living exhaustible natural resources. That would clearly include fossil fuels and uranium. If such measures are made effective in conjunction with restrictions on domestic production or consumption. So as I read this, Canada is poised to give away our right to control our resources such that we might decide we need Canadian oil for Canadians, it's time, or we don't want to continue to sell, we want to conserve uranium. We would only be able to reduce Chinese access to our resources to the extent that we reduced our own access to our resources proportionally, which reminds me very much of the energy chapter of NAFTA and raises an issue in my mind. We're committed under the energy chapter of NAFTA to never reduce the proportional share of exports that have gone to the United States historically. So if 60% of our natural gas is sold to the United States, our total production of natural gas must always be 60% committed to the United States. What happens as burgeoning growth in Chinese resources begins to compete for the percentage share that we've already promised the United States, and we're not allowed to limit the Chinese share anymore, except to the extent we're willing to reduce our own production. Now, this agreement is stated to last for 15 years. Either contracting party can file a 1-year notice to get out of it, but any investments made before the notice to get out of it is filed will be in effect for 15 years. This agreement also includes a provision that there is a 21-day grace period for review in each other's country. That 21-day grace period from when Stephen Harper signed this is up, so I'm wondering what process is planned for Canadians. This document was tabled without notice, without any technical briefing. I've spoken to Trade Minister Ed Fast and asked for a briefing. There is no technical briefing planned for this treaty for the media or for MPs. The second agreement, I'll just make a brief reference to it before opening for questions. This agreement is an agreement for the peaceful uses of nuclear energy. In my view, this document violates the Nuclear Nonproliferation Treaty. It does not have sufficient rigor for verification for us to meet our obligations that we will not sell uranium to a nuclear state without adequate guarantees and safeguards that our uranium will not be diverted to nuclear weapons. The agreement is here, but I question whether it has sufficient safeguards. It's, as you can see, it's an agreement of approximately a page, and it involves a commitment by China, but it does not include any verification procedures or penalty measures. So I'm concerned that it's a fig leaf over Canada's continual disregard for nuclear nonproliferation. And with that, I'll open to questions.